1.
The clerk will open the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
We're ready to hear argument in PD-0556-20, 5-0 versus the state of Texas.
Good morning. May it please the court. My name is Clint Morgan. I'm an assistant district attorney for Harris County, and I represent the state of Texas. This case involves a court of appeals conducting the wrong harm analysis and then doing so poorly. I'm going to divide my argument into 3 parts here. The first, addressing which harm analysis was appropriate in this situation. The second, reviewing the ways in which this harm analysis they conducted, even under their standard, went awry. And then the third, I'm going to sort of address some of Mr. Wood's arguments from his briefs, which were not directly responsive to the arguments in my grounds for review or in the Court of Appeals opinion, which is why I've reserved an uncommon amount of time for rebuttal, as I'd like to hear what he has to say on the subject and discuss that a bit. So this case involves, at a very basic level, simply unpreserved charge error. And we have a very well-established standard of review in the state of Texas for that, and that's the Almanza egregious harm standard. Now, the Court of Appeals here just simply declared that it had been preserved. They did not discuss it. I filed a motion for reconsideration pointing out this was not in any timely manner preserved, but they still conducted the constitutional harm analysis, and this directly conflicts with their other opinion in Niles. And it conflicts with pretty much everything the federal courts have done. I cited the Johnson, which is a pre-Apprendi case from the Supreme Court, but it still says that this type of error, when it is not objected to, is exactly like every other type of unobjected to error, subject to, at most, federal plain error review, or I guess in Texas, an Almanza review, which is structurally and substantively similar to federal plain error review. And I think Johnson is probably the most instructive case here. I admit in my original briefing in the Court of Appeals, I assumed this was going to be constitutional error. I did that based on the discussion in this court's original opinion in Niles, which cited to other cases treating this as constitutional error, but I just don't think that applies here. And certainly neither the 14th Court nor Mr. Wood have given me any argument as to why this unpreserved error would be subject to a constitutional harm analysis.
Why would we expect the defense to object to a lesser offense? Like, why would we expect them to object to a Class B offense and not and insist on, well, you charged me with a Class A, shouldn't you put the Class A in there? Why would they do that if it, from their perspective, they're seeing it as an abandonment? Why would we expect them to object at all?
Well, first, I'm not sure from their perspective this was seen as an abandonment. But second, we expect defendants to object when their rights are violated by things. Right here, the defendant's right to have the jury determine all the elements of the offense was violated by the trial court's failure to put this instruction in the jury charge. We normally expect defendants to object to that sort of thing because it's his right. Now, whether he saw this as an abandonment, there's no particular reason in the record to believe that. Certainly not.
Can I interrupt you on that? Because what reason is there to believe that it was anything other than that?
Well, I will tell you, it's been long. Taking a step back, this court's jurisprudence, and I'm not here to bicker about this because I think the cases are mostly correct, but it is confusing sometimes as to whether issues are guilt phase issues or punishment phase issues. And I think this court has done a good job working through some confusing legislation on this subject, but at the end of the day, there are good faith, people can have good faith disputes about whether something goes at the punishment phase or something is a guilt phase issue.
I don't think you're answering my question.
Pardon?
I don't think you're answering my question. My question is, what in the record should cause anyone to believe that the state did not intend to abandon that element in the presentation of the case to the jury?
The fact that the state did not make any statement that they intended to abandon that element. There was no filing along that. The defendant has pointed to Gray's statement that the state without prior notice can abandon an element, and that's true, but that doesn't mean the state will default an element by just not mentioning it.
And the state
Well,
did not
actually,
object. So,
counsel, that was actually one of the things that caused me some concern because I thought about that Gray case and I was like, well, Gray is distinguishable, right? Because that was a situation where the state was affirmatively requesting a lesser, and then the argument was whether or not you could get a lesser, even though the greater offense hadn't been negated. And we said that's fine as long as they decide that they want to request a lesser. But then I'm like, but they kind of did request a lesser, or didn't they? I mean, if they're basically putting in the jury charge this lesser offense, and you're saying that it's guilt error, why wouldn't we just interpret it what they submitted to the jury? What was submitted to the jury is a submission of a lesser included instead of a greater offense.
Your Honor, I think, first of all, there's no precedent in the case law for holding the state to just a passive abandonment of an element. If that was the case, then all of these cases I've cited where the state failed to read elements in the indictment at the beginning, or the state completely failed to read the indictment whatsoever, those would have been held to be abandonments, and that has simply never been the case in this state. Now,
what if the defense had complained about something else on appeal, and what had happened at trial was the trial court submitted the lesser issue and the state objected to it, to the failure to include the greater issue in the jury charge, and the state had objected to it, and you would get to a place on appeal where then you would be able to file a cross point on appeal, right? If the defendant there was a different issue that the defendant had raised on appeal, you could raise a cross point, and you could then complain about the trial court's failure to submit the greater offense that you thought the jury should be able to consider. But if you don't object to it, then we would consider that to be waived. We would say you can't raise that here, state of Texas, because you didn't object to it at the trial court level.
Right. So where I was going to earlier, Your Honor, about confusion about where elements go is the case from the 14th court holding that this particular 0.15 is a punishment phase element stems from an old Harris County practice where our courts, about half of our misdemeanor courts, were putting the 0.15 element in the guilt phase. About half of our misdemeanor courts were putting it in the punishment phase. And that resulted in the case of Navarro, where that was treated as a punishment phase issue. And then it was very difficult. You're asking about a cross point on appeal. I actually wanted to do that in Navarro, and it was very difficult to do it. And the only way I was able to get that addressed in Navarro was because in a truly bizarre turn of events, the evidence was actually insufficient to support the 0.5 finding. And so, I mean, we did not object to that in Navarro, but the Court of Appeals had to address it, and that was not addressed as a matter of waiver. I don't know why. I mean, I don't think that's necessarily true, Your Honor, that this would be waived if we raise this as a cross point, because the trial court has its own obligation to properly charge the jury, and this would be a matter that would be reviewed on remand if there was a reversal. So I think this could have been addressed on a cross point. I don't think it's waived. I don't think there's any precedent in the case law for the state just passively waiving something without addressing that and without requesting to do so.
Well, let me back up then, counsel. Why is this not an enhancement? Why is this guilt, innocence, or not? No one cited to Oliva. Oliva seems to be fairly instructive on how we determine, and even with DWI cases, how does this shake out under the Oliva analysis? Is this a punishment issue? Is this a guilt? You're taking the position as a guilt innocence issue. Why is it not an enhancement?
Because it deals with the conduct that's related to the offense itself. And Oliva sort of acknowledged that when we have this kind of vague language describing whether something is it's at least ambiguous as to whether it's a punishment or a guilt phase issue, then we look at whether it regards the actual conduct of the offense itself. And here the 0.15 element does. What
if it was a capital murder case we were dealing with, and the element that was left off was that it was an officer in the lawful discharge of his duties. And it was just, the murder case was presented to the jury. State did not object. I mean, is that analogous? Would we be saying it's okay for the trial court to supply the finding in the punishment phase that, after all, everybody knows it was a police officer in the lawful discharge of his duties, so I'm just going to supply that finding, and then we'll convict this guy of capital murder and sentence him to death?
Well,
okay?
With the caveat that death cases are sort of sui generis here. Other than that, that's the exact profile of Niles. And the Court of Appeals on remand found that that was harmless in Niles because it was completely uncontested that the complainant in Niles was a public servant at the time of the offense.
Why, I'm sorry, counsel, why not apply the egregious harm? Why are we applying egregious harm instead of the constitutional error harm that the Court of Appeals applied that we sort of alluded to in Niles?
Because it's simply unpreserved, and the Supreme Court case in Johnson shows that when this type of error is unpreserved, the constitutional error is unpreserved. This is subject to forfeiture, exactly like most constitutional rights are. And in Johnson, there was this exact same issue. It was it was the federal courts were deciding an element during the punishment phase by the judge instead of the jury. And the Supreme Court held, no, you've got to object to that prior to the submission of the jury charge, or else that's waived, and you still get plain error review, but that's it. I think Johnson is controlling on that point.
Who's raising jury charge error in this case?
I believe. So I understand where you're going with this. This is
just a simple question.
Right.
I think most questions are easily answered if you just take them one at a time. And when I look at this case, what I see is it's the state that's raising the jury charge error here.
Right. So Mr. Wood was raising this as an illegal sentence claim. And the fact of the matter is literally anything can be raised as an illegal sentence claim through creative drafting. And I think courts have been generally reticent to just simply let any issue get shoehorned into an illegal sentence claim, because once you do that, then all rules of preservation and forfeiture go out the window, and suddenly everything's preserved regardless of whether it was presented to the trial court. And so he presented this as first an evidentiary insufficiency claim, and then later admitted that that was incorrect, and then submitted it was an illegal sentence claim. But then an illegal sentence claim is just a way for someone to get an unpreserved error in front of the trial court or in front of the appellate court. And I don't think rules of preservation should be so easily defeated through just artful pleading on appeal.
What was the holding?
Excuse me. Let me ask you one question. Let's assume that the state did plan to abandon this punishment enhancement, and they went through the whole punishment trial and didn't say a word about it, and they clearly intended to abandon it. Would there have been error in the guilt phase in that situation?
If the state had wished to abandon it?
Yes.
But if the state had never, I assume at some point in time that's going to have to make itself known. I see what you're asking, and I don't think in the situation where we don't ask for the enhancement in the guilt phase, it doesn't make its way into the judgment. And so I don't think there's any error there. Had the judge just entered a judgment for Class A, then yeah, I think that probably would have honestly negated our abandonment if we had never said we wanted to abandon it. Much like defendants, we need to often voice our thoughts on subjects.
But my question is, assuming that it was intentionally abandoned and the judge didn't do anything, it went all the way through punishment as a Class B, was there any error?
No.
Okay. And then why should the defendant in that situation be required to object to something that's not error if it goes the way it appears that it's fixing to go?
Because frankly, these are his rights and he needs to clarify these things. And there's a lot of communications between the parties prior to trial, and it would be very uncommon for that sort of thing, I think, to go through without them being aware that we're doing that. If we've not told him we intend to abandon it, has no particular reason to think we need to abandon it, it would be a very weird case where the state just defaulted an issue, and there's frankly no precedent for the state defaulting an issue like this, defaulting an element of an offense.
Counsel, you're getting into your rebuttal time. Did you want to say that?
Yes, I will save that, Your Honor.
Thank you. You may proceed.
Good morning, and may it please the court. I emphatically reject the idea that there was any jury charge error in this case.
Counsel,
And
I know that this is being recorded and it says Ted Wood, but would you please say your name for the record?
I apologize, Presiding Judge Keller. My name is Ted Wood. I'm an assistant public defender with the Harris County Public Defender's Office, and I represent Mr. Doe in this case.
Thank you.
Did
All right.
counsel, did the lower court say there was jury charge error? I thought we were only determining what the proper harm analysis was for jury charge error. But did they say below that it was that? Is that part of the decision we're reviewing?
The lower court never specifically said this is jury charge error, but they immediately started addressing what the proper standard of harm was, not standard of harm, but they immediately started talking about Almanza and about constitutional error and so on. It was clear, although implicit, that the 14th Court of Appeals found there was jury charge error here. Otherwise, they wouldn't have gone into this harm analysis.
All right, thank you.
Sure. The state relies on the Niles case and says that this case, Mr. Doe's case, is essentially the same, very similar to that, but there are some significant differences. And here, the prosecutor at what we informally call arraignment never read the second paragraph of the information to the jury. The prosecutor only read the first paragraph. And that's different than in Niles, where the paragraph containing the aggravating factor, the public servant factor in terroristic threat, was read to the jury. The second difference is that here, because the second paragraph, the paragraph about the 0.15 or higher DWI, was not read to the jury, when the defendant pled not guilty to the information, he was pleading only to the first paragraph. And so issue was joined only on the Class B misdemeanor, the regular DWI. And here, similar to the Niles case, the jury was perfectly presented with a complete offense, with a Class B misdemeanor. And the jury actually, in its finding, said they found the defendant guilty as set out in the information. And while the information did have both paragraphs, including the aggravating factor of 0.15 or higher blood alcohol content, the jury was never aware of that second paragraph. They only knew about the first paragraph. That's what issue was joined on. So I feel that there was no jury charge error here at all. I think it would have been ridiculous, really, to expect that the defendant should lodge an objection at the charge conference. And in this way, the case is very similar to Niles. And what Judge Yeary said in his dissent was, well, what would you expect the defendant to object to? An objection to the state exercising its unfettered discretion to charge the defendant with a lesser included offense? And I think even more so and even more strongly here, we have a similar problem. You know, what would the state suggest that Mr. Doe's objection should have been? And to put it kind of the way Judge Yeary put it in Niles, could it have been, Your Honor, I object. The charge omits an element of a greater offense that was never read to the jury and to which I did not plead. It would be kind of ridiculous. And there's a very good dissenting opinion, I think, when the Niles case was sent back to the 14th Court of Appeals. And this dissenting opinion was written by Justice Borleo. And what she pointed out was that there might even be an ineffective assistance of counsel claim if the defense counsel in this case were to have objected to the state not asking the charge to reflect the more serious offense. And I think she has a point, though, although that was in a dissenting opinion, but I think she does have a point. So when we get into a discussion of the harm, it's all based on the fact, premised on the fact that there had to be a jury charge error in the first place. And that's why I have responded the way I have in my briefing, is that I just don't accept that idea that there is a jury charge error in this case. That's not to say that there is not an error in the case, but the error occurred in the punishment phase when the judge decided on his own that the 0.15 or greater issue question was decided in favor of the state. And that was the wrong place for this to happen. There was some questioning earlier by some of you to Mr. Morgan about whether this 0.15 issue is an element of the offense or is it a punishment issue? And there was some question about whether this was an Oliva situation. And I'm well aware of the Oliva situation because that was a case I argued to this court.
Why I asked the question.
Okay, well, I'm aware, Judge Newell, that you knew that very well. But we have, first of all, I want to address that it's an element of the case. There's quite a bit of case law on that. And the Navarro versus State case said that the 0.15 element, it is an element of a separate offense because it represents a specific type of forbidden conduct, operating a motor vehicle while having an especially high concentration of alcohol in the body. And I think Mr. Morgan probably accidentally said that Navarro stated that this was a punishment issue. It's not, it's an element of the offense. And there's other case law on that. The Navarro case, by the way, is out of the 14th District Court of Appeals. The Castellanos case, this is a 2016 case out of Corpus Christi. That also has decided that the 0.15 issue is an element of a separate offense. So I could go on and cite some more cases on that. There's another one out of the Diamond versus State out of the 14th Court of Appeals, very recent by Judge Jameson. It says, however, the jury also found that an analysis of appellant's blood showed an alcohol concentration of 0.15 or more. That finding is a required element of a Class A misdemeanor. She even called it a special issue. I think something that's relevant in whether we view this as a jury charge error or not is that if we look at harm, if this is a jury charge error that I was supposed to bring, not I, but that Mr. Doe was supposed to bring up and advance, then the next question would be, well, what harm is there? Isn't this harmless? And you know what? It's totally harmless in the view of Mr. Doe, because if the error was that he should have been charged with a Class A. The jury should have been charged with deciding a Class A misdemeanor instead of a Class B misdemeanor. How, under any kind of standard, could that possibly harm Mr. Doe? It was completely harmless to Mr. Doe. He wanted to have the Class B misdemeanor charge go forward, not the Class A misdemeanor charge. So I would argue that if this court were to somehow decide that this was a jury charge error, that it was Mr. Doe's obligation to complain about, you next get to whether that's a harmful error to Mr. Doe. It doesn't make sense to say that it's harmful. It's clearly harmless. Now, the error that was made in the punishment phase, that certainly was harmful to Mr. Doe. That's another discussion entirely. And it seems to me, if we look at what happened in this case, that the state was proceeding on a misunderstanding of what the elements were in Class A misdemeanor DWI. At least Class A misdemeanor DWI, when it's a 0.15 or higher blood alcohol content that is the aggravating factor. They seem to think that this was a punishment issue, and that's exactly the way they handled it. As soon as the punishment phase opened up, they said, well, now we'd like to talk about the 0.15 or greater finding. And the trial judge made an error there, I believe. There was an objection. I don't think there's any question that there was an objection to that by the defendant, but the trial judge overruled that objection and said, yes, I'm going to make the finding that it's a 0.15 or higher blood alcohol content. And based on that additional finding, then we're going to have a punishment in the Class A range. And I think that was a mistake for a couple of reasons. First of all, it's pretty clear that the element must be proved during the guilt innocence phase. And I do have some law on that, going back to the Colton v. State case written by Judge Kiesler in 2005. An element must be proved at the guilt phase. And going to Castellanos v. State, this is from the Corpus Christi Court of Appeals. The issue regarding the blood alcohol level was for the jury to find at the guilt innocence stage of trial. And in fact, here, the state admits that the 0.15 or greater issue is an element of the offense that must be proved at the guilt innocence phase of trial. And to cite from the state's brief at page 11, it says, when a defendant is charged with the Class A misdemeanor of DWI with an alcohol concentration of 0.15 or greater, the issue of whether the defendant's alcohol concentration was 0.15 or greater, and this is the key, is an essential element of the offense that must be proved to the jury at the guilt phase of trial. The state admits that right in their brief. And so we didn't have a finding of all of the elements of the Class A offense, not at the guilt phase of trial. And even if you say, well, it's okay to have that finding at the punishment phase, then you get into Apprendi problems, because you have the judge making the determination that Mr. Doe's blood alcohol content was 0.15 or greater, not the jury. And Apprendi, of course, tells us that any fact that is going to weigh in on punishment, make the punishment greater, that has to be found by the jury in a jury case. And that certainly wasn't done here. In fact, the jury had done. I'm sorry?
Didn't he request a court to assess punishment though?
He assessed the court to assess, he asked the court to assess punishment. That is true. So maybe you have a good point there, Judge Newell. Maybe if that's done,
maybe,
and it was okay, yeah, maybe if that was asked for and it was okay to prove this up in the punishment phase, maybe there wouldn't be an Apprendi problem. I'd have to think about that a little more. But we don't even really need to get there because the law is out there and the state admits that this is an element that needs to be proved during the guilt-innocence phase of trial.
If we assume that if the court doesn't go with the abandonment theory or the idea that this was abandoned at guilt, is there a conflict between the standards of harm between this case and Niles 2? And if so, how do we resolve that?
As I recall, Niles 2, you're talking about the 14th Court of Appeals treatment of because you had sent it back to them to do a harm analysis.
Correct.
And maybe you can refresh my memory. I have the case here. I believe this is Niles 2, but maybe you can refresh my memory. What did the Court of Appeals finally do on the harm analysis?
I believe they analyzed it for egregious harm.
Okay, so if this was a jury charge error, as the Niles court decided that it was in that case, then it's appropriate to analyze whether the error was preserved. And so Almanza comes into play, and whether if the error was preserved, then there has to be egregious harm. And if the error was not preserved, then there just has to be some harm. But I believe, if I understand your question, Judge Newell, you're saying, what if we don't say there was any jury charge error and we just look at the error in the punishment phase?
No, I was saying that if we agree that it was jury charge error, don't we have conflicting harm standards between these two cases?
I'm not sure I'm following that, Judge. I apologize.
One of the first questions I asked was whether or not this was jury charge error from the Court of Appeals decision. The Court of Appeals, even you mentioned that while they don't quite specifically say that it was jury charge error, they do cite to all of the cases that are associated with determining harm after jury charge error. And so their analysis, however, seems to get the harm standard incorrect for unobjected to jury charge error. So is there a conflict or is there not a conflict? Are you just asking us to improv grant? How would you analyze it to suggest that if we say that this is jury charge error, that it was harmful?
The premise of your question is that I would want to show that the jury charge error, if there is one, is harmful. And what I've said earlier is that there's no way I can show that. There's no harm to Mr. Doe by the decision to charge the jury only with the Class B misdemeanor. There's absolutely no harm to Mr. Doe. If this honorable court finds that that was a jury charge error, I have no argument for you about how that harmed Mr. Doe, because it simply did not. Now, Mr. Doe was harmed in this case by what the trial judge did in the punishment phase, but the harm there is not subject to an Almanza standard for jury charge harm, because there was no jury, there was no jury charge in that error. The error was a constitutional one, because under In re Winship and a whole series of cases in that line, both the Sixth Amendment right to a jury and the 14th Amendment right to due process combined, they say that there has to be a finding of every element of the offense. And in fact, we say that in our statute, in the Code of Criminal Procedure, Article 38.03. All persons are presumed innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. And that's the problem. Every element of the offense was not proved beyond a reasonable doubt, not at the guilt phase. And I will add this, Judge Newell, I think that if you read the Court of Appeals opinion in this case, it gets a bit confusing about what harm standard they are applying. They talk a little bit about a harm standard under Almanza, and then they start talking about a constitutional error harm standard.
So which one is it?
Well, if this court decides that there was jury charge error, then the Almanza standard kicks in. And admittedly, Mr. Doe made no objection, preserved no error about a jury charge error in the trial court. So he would have to show egregious harm. But again, my point is that Mr. Doe can't show egregious harm. He couldn't even show some harm because there is no harm that came from the court's decision to charge the jury with a Class B misdemeanor. There was absolutely no harm there.
Counsel, your time is up.
Thank you, Presiding Judge Keller.
Thank you, counsel.
Your Honors, there's simply no precedent from this court, from the federal courts, to treat a situation where an element is omitted from a guilt phase jury charge as an abandonment of that issue. If that was the law, then Niles would look different, then Nieder would look different, then that entire string side of cases in Niles about harm analysis would look different. Every single thing in this area of the law would look completely different if the failure to submit an element was something other than jury charge error, as the federal courts have treated it, as this court has treated.
Mr. Morgan, did the state read the .15 allegation at the onset of the trial?
No, and he did not object to that either. And so
why would he object to it?
Because that the law puts the burden on the defendant to object when the state improperly fails to read the indictment at the beginning of trial.
Well, I mean, he would be sitting there thinking, well, they're not going forward on the .15. Why do I want to make an issue of a Class A misdemeanor versus a Class B misdemeanor?
I'm going to question this.
I'm the defendant sitting there thinking, I'm content to go forward on a Class B. They've charged me with a Class A, but they haven't put the jury on notice about it.
So, Your Honor, I'm gonna contest that he actually had this thought based on the nature of this element. The element is above 0.15 or not. He knew we were going to put on evidence it was above 0.15. This isn't a case where we have a missing witness, where we have some sort of question about age of a complainant. There's absolutely nothing subjective about this. There is no reason whatsoever for him to have ever thought, no, the state can't prove 1.5 or 0.5.
Did you put on evidence of that?
We did.
Okay, and it's in the information.
The information alleges it, and
as a Class A.
Yes.
Okay.
And he
knew. Why would you not read it at the onset of the trial?
Because, and there's every reason to believe the trial prosecutor believed that this was a punishment phase issue.
Why? What reason do we have to believe that? Did it come up before the court?
Yes, during the punishment phase, he says this is a punishment.
Prior to the punishment phase.
No one mentioned it, but if the prosecutor in good faith believed it was a punishment phase issue, it would not come up prior to the punishment phase. And so part of what the question here, the bigger question here is, what are the consequences when a prosecutor is incorrect about whether an issue is a guilt phase or a punishment phase issue? And under the analysis that Mr. Wood has put on, the defendant has no burden to ensure that his Apprendi rights are protected by having the proper issues at the guilt phase, and the state bears complete strict liability for being wrong about this and inappropriately thinking something is a punishment phase issue. That's the position that he's advancing. This is all on the state. The defendant has no obligation to ensure his rights are protected, and that it is strict liability. And there's no precedent.
I would think the better argument would be the defendant has no obligation to ensure that the state is going to prove him guilty of a higher offense as opposed to a lesser offense. Why would he do that? I mean, his lawyer would be ineffective if he did that. It would be like murder versus capital murder.
The case law does not bear that out, Your Honor. The case law shows that when elements are improperly put off until the punishment phase, that there has to be a defense objection to preserve an Apprendi issue. The case law bears that out. And certainly the case law would look different. If that was the case, that you had a burden to object. I mean, it's if you look through the cases that are cited in the string side in Niles, particularly the Alabama case, right? It put off until the punishment phase the age of the complainant in a sexual assault of a child case. And that plainly seems kind of like a guilt phase issue. And it was not sent to the jury in the punishment in the guilt phase. And the defendant did not object until the punishment phase. And it was not held to be sort of an abandonment of the issue, because there is simply no precedent for that. Nieder would look different if that was the case. Johnson would look different if that was the case. Niles would look different if that was the case.
Does Apprendi make any, does Apprendi matter? Like, does it matter under Apprendi when the jury does it? Does it have to be in the guilt phase? Does it have to be in the can it be in the punishment phase?
By my reading, no. Apprendi would be fine if a jury did it in the punishment phase, though jury sentencing is, of course, uncommon throughout the country.
Sure.
So I don't think they would have addressed it, but no, I think Apprendi would have been fine had this been decided in the punishment phase by a jury.
And does it make a difference regarding Apprendi that the defendant chose to go to the judge for punishment?
I don't think it does. You would need to show some sort of affirmative waiver there. I don't think for Apprendi I don't think that necessarily forfeits his Apprendi claim. Simply choosing to go to a judge. I think it could have saved an Apprendi claim had he gone to a jury, but I don't think it forfeits it by him going to a judge. Might be the correct way to look at this. Now, I would quickly like to address his assertion that by not reading this element at the beginning, there was no issue joined, and that things not read at the beginning or pled to are necessarily abandoned. And he cites in his brief a case from 1981, Peltier, which has case law going all the way back. And you can trace this rule to 1884, when the Court of Appeals looked at the order of trial statute, which says the state shall read the indictment. And they said, well, that's a mandatory part of the statute. But then they also hem and haw that other parts of the statute are, this is very short, Your Honor, may I exceed here. Other parts of the statute also say shall, like you shall give an opening statement. The defendant shall put on evidence. And over time, this got bogged down in this court's mandatory statute versus merely directory statute area of case law. And the upshot of that is that has all been now subjected to harm analyses. And so the failure to read an element at the beginning of the case is simply routine trial error, subject to forfeiture, subject to harm analysis. This idea of automatic reversal, of automatic abandonment going back to the 19th century, that does not comport with modern case law of this court.
Thank you, counsel.
Thank you for your
The
time.
case is submitted. Court will stand in recess until 10 o'clock.